down. You're gonna cut it out, aren't you?
I don't even know how to do that now. I have no idea how to do this.
There you go, there.
Good morning. Hello, Angela.
Hello.
Good morning, Angela.
How's your week going?
Good.
Very good. I'd like to reflect that Angela's week is going well. See what a friendly group this is?
Yeah.
And see, you thought accountants were just an unfriendly bunch. You see how wrong your misconceptions were?
Absolutely.
Question number 1. Katie, Frost accountant and business manager has the authority to 1. Mortgage Frost business property, 2. Obtain bank loans for Frost. Isn't A and B the same thing? So we can ignore those, I think. And also, it's thinking AJ, in terms of what can you do in the ordinary course of business? And something that you do every day is not take out a loan. Something that you do every day, AJ, is not sell the business. I mean, you do that, how often? You do that once, because once you sell the business, you're gone. Therefore, AJ, the answer must be C. Katie, you agree? Question number 2. Candace. Trent was retained in writing to act as post agent for the sale of post memorabilia collection. Which of the following statements is correct? To be an agent, Trent must be at least 21. Candace, that is false. 2, could be post with reliable Trent to Trent if the collection was destroyed before Trent found a purchaser.
False.
Why?
Because it can't be liable for something that happens and destroyed.
And it's not Trent's fault. And also, there's no evidence of negligence. There's no evidence that it was even in Trent's possession. So unless we read facts in here or they're not there, which you could easily do, that would be false. So therefore, now that I know both are false, Candace, the answer is D. Question number 3. Greg, Noah gives Carr a written power of attorney. Which of the following statements is correct regarding his power of attorney? So let's turn this into a true-false question. It must be signed by both of them. What do you think, Greg? False. It must be signed by the principal, but not the agent. It must be for a definite period of time. It must be for 6 months. It must be for 9 months. It must be for 18 months. Or, Linda, could it be indefinite?
No.
It cannot be indefinite? Craig is saying yes. So I could appoint you as my power of attorney for a 6-month period, or for a given purpose to sell my land, or I could just name you the power of attorney until the end of time. But Greg, it cannot continue past my death. Why?
Terminates it.
Well, because a decedent cannot enter into a contract. So it seems like A, B, and C are all false, Greg. It may limit Carr's authority to specific transactions. It may not. Could be a general power of attorney, or could be a power of attorney to sell land. For example, my sister and I own some land in Alabama that we're trying to sell. And so, Greg, I gave her the power of attorney for the specific purpose of selling that land. And was it drafted to limit her authority?
Yes.
Yes. Question number 4. Again, which of the following actions requires an agent for a corporation to have a written agency agreement? So here, Megan, the question is not the agency itself, The issue is whether the transaction itself has to be in writing. So it's not the agency relationship, it's whether the transaction itself has to be in writing. So Kayla, what about purchasing office supplies for the principal's business? So to purchase supplies, that contract does not have to be in writing. Therefore, the agency agreement need not be in writing either. Megan, purchase an interest in undeveloped land. Since that's a contract for an interest in land, the contract itself must be in writing. Therefore, the agency agreement must also be in writing. So our whole thing seems B. Hiring an independent general contractor to renovate the principal's office building. Well, Megan, that contract itself need not be in writing. Therefore, the agency agreement need not be in writing. And then Caleb, retaining an attorney to collect a business debt owed the principal. That doesn't have to be in writing. Now probably, candidates, many of these should be in writing, just so there's no misunderstanding, but legally don't have to be. So the only agency agreement, Megan, that has to be in writing is B, and that's because the underlying transaction itself has to be in writing, because in the statute of frauds, Kayla, this is an interest in land. Question number 5. And which of the following acts, if committed by an agent, would cause a principal to be liable for a third party? And notice the symmetry here. A and B both deal with independent contractors. C and D both deal with employees. Notice also that Jody, A and C deal with acting within the scope, and B and D is acting outside the scope. So, Anne, I need to eliminate some of these. Which one would you eliminate first? I would eliminate B and D because this is outside the scope. So I can't be held liable if it's outside the scope. So therefore, the answer would either be Jody, either A or C. And here is an independent contractor versus employee, and I'm generally not liable for the acts of an independent contractor. Therefore, the answer would be C. So therefore, we could eliminate, we could, David, simplify this by cutting down the, eliminating 2 answers. So, notes for the day. Principal is liable for the agent's acts when the agent has either actual or apparent authority. Actual authority is either expressed or implied. Apparent authority is under estoppel, emergency, and ratification. So Candace, let me understand this. I know what express authority is. Candace, express authority is what everybody knows you have. I appoint you as my agent. So express authority is what everybody knows you have. For example, I appoint you as my agent to sell my land in Alabama. You have the authority to sell my land. But what's the difference in implied and apparent? The implied authority is what you think you have. The implied authority is what the agent herself thinks she has. Kobe, if I appoint Candace as my agent to negotiate a land sale with you, the apparent authority is what you think she has. So again, the implied authority is what the agent thinks she has. The apparent authority is what the third party thinks she has. Actually, the implied authority, and Kayla, I don't need to make a distinction from the express authority because everybody knows what that is. There's no disagreement. So again, the implied authority, Candace, is what you think you have as my agent. And the apparent authority is what the third party thinks that you have. Express authority can be either oral or written. Equal dignity rule law requires written contract and agent. Megan, this rule is what we used for the CPA questions you and I did earlier. Law requires a written contract, then the agent's authority must be in writing or the contract is voidable, and that makes sense. Express authority, exceptions to express authority is an executive officer acting for a corporation. Later, when we talk about corporations, We'll talk about that every officer is an agent of the corporation. Also, next week, when we talk about partnerships, every partner is an agent for the partnership, which is, Kayla, why we do agency before we do partnerships. Agent acts in principal's presence, and that makes sense, because if I appoint Candace to negotiate a land sale with Kobe, but the three of us are in the room, then I'm doing the talking, then I'm taking away your authority. That makes sense. It's only when I leave the room, or if I stop talking, that you have authority. When the agent's act of signing is a mere formality. Do the following agency agreements have to be in writing? Jody wishes Katie to be her agent for the sale of land. Jody?
Yes.
Yes, why?
Because the sale of land is a contract that would need to be in writing. So according to equal legal.
Let the record reflect that I should ask no more questions of Jody because she can't talk today. What if Katie agrees to do so? What if Jody agrees to do so for no payment? What are the implications, Matt? Does it still have to be in writing? And Matt, do you think it would often be the case that an agent would act without pay?
Would probably say no, they wouldn't act without pay.
Well, not within a business context, but what if within a family context?
Yeah, I'd probably say so.
For example, if I did my sister's tax return, and there was some issue with the tax return, she may give me a power of attorney to talk to IRS on her behalf. But do you think she's going to pay me?
No.
So David, what are the implications if the agent agrees to do it with no pay? Does that change whether the agency agreement has to be in writing or not? So does that change because the subject matter is the sale of land? So it still has to be in writing, or otherwise the other party can get out of it. Candace wishes Jody to be her agent for the sale of inventory. Candace, does that have to be in writing?
No.
Unless it's for a consumer good more than $500. So the way it's stated, the answer is no. You agree? Now, Candace, what if Anne wishes Bijou to be her agent to hire staff for her restaurant? What do you say to that, Candace? Yes?
Probably.
Probably. Well, let's talk about that as a strategy on the CPA exam. Generally, Candace, the CPA exam only tests black letter law. I mentioned that before. What does that mean?
Like it's black and white or,
Yeah,
it's a clear
black and white. It's clear answer. There's not, and so we probably want to eliminate the word probably in your answer, because in the CPA exam you don't see that situation. But give me a situation where it would have to. So the answer is generally no. But I could add a fact, and on the CPA exam you don't want to do that, do you? You want to take the facts as they are. But if I were to add a fact, I could change this to make it be required in writing. Just suppose that you're going to hire a manager for an 18-month contract. Then that is a contract that cannot be performed within a year. You agree? But notice, Alex, I'm adding facts that are not here. So based upon what I have here and what I have here, the answer is no. I could change the facts, Taylor, and change the answer. But Taylor, isn't that always the case? Change the facts, and change the answer. Express authority. Power of attorney. Power of attorney is written document, usually notarized. Candace, it doesn't have. Well, Candace, what's it mean to be notarized?
that it's.
I go into a notary public. I show her my ID. And then I sign it in her presence, and then she stamps it with her seal, basically says that this is a legitimate signature. I watched him sign it, and I matched it against his ID. Now, I don't have to have it notarized, but Kelsey, I probably should. Why?
To make sure it's enforceable.
To make sure it's enforceable, and also to make sure that the person who's acting on the power of attorney, that you believe that person, and so forth. So it doesn't have to be, usually is, it should be. It could be a special, which is for specific acts only, for my sister to sell the land that we own in Alabama, or it could be all business for the principal. Terminates on principal's death or incapacity. Candace, why? Why does it terminate on the principal's death?
Because the principal can't make a contract.
Because if Keith Harrison's dead, he can't make a contract. So therefore, the power of attorney would end beyond his death. It also ends beyond his, when he becomes incapable of making decisions. So when Jack Winstead becomes legally incapacitated, he can't enter into a contract. This is a little beyond the scope of the CPA exam, but it's an interesting point. Have you ever heard of a durable power of attorney? What a durable power of attorney survives the incapacity of the principal, and it's usually used for healthcare decisions. A durable power of attorney, once somebody becomes, let's suppose, Linda, somebody goes into a coma, then they're legally incapacitated because Candace cannot make decisions. But I might want to appoint somebody with a durable power of attorney specifically for the purpose of making healthcare decisions. Probably not my sister if I'm going to give her the authority to pull the plug. I don't have to think about that. But the general point here, Candace, is that a power of attorney terminates at the death incapacity, and that creates unique problems with healthcare decisions, which Linda has solved with her durable power of attorney. How'd you know that? Really? I'm impressed. Implied authority, what is reasonable and necessary to carry out express authority. And again, Candace, this is, you're my agent, the implied authority is authority you think you have. And you think about it, yes, suppose, Candace, I appoint you to manage my business for me. I cannot possibly think of every detail that I would ask you to do. And if I did, the document would be 100 pages long. It'd be like the roommate agreement in the Big Bang Theory. Can be inferred or conferred by custom or agent's position. The agent reasonably believes she had authority to do the act. And Candace, remember we talked about this last time, where Winstead appoints Harrison as his agent when he's in Tibet, finding himself. And Harrison was appointed as his agent to manage his apartment complex. And so it would be reasonable, Candy would be reasonable for Katie. Sorry. It would be reasonable for Katie, I just added an in there. It would be reasonable that he would have authority to collect the rent. It would be reasonable, Taylor, that he has authority to make repairs. It would be reasonable, Kobe, to say that he has authority to buy insurance. Because all those are things that you do in the normal course of business. It would not be reasonable, Linda, to say he has authority to sell the apartment building or to take out a second mortgage. But would it be reasonable to assume, Candace, that he could create an accounts payable to pay the plumber? Because otherwise, everything would have to be done in cash. And why, Candace? Why is it when the plumber comes and the plumber says, if you pay cash, I will give you a discount. If you pay by check, it would be full price. Why is that? Do you think Brandon, they're worried about bad checks? Let me state the issue again. The plumber says, and electricians do this and so forth, the plumber says, if you pay by cash, I'll give you a 20% discount. Pay by check is full price. Are they worried about bad checks?
Yeah.
Kelsey, are they worried about bad checks?
Yeah.
And somebody's got to be cynical enough here to see the tax evasion motive. Because if there's a check, there's a paper trail. Candace, if there's cash, there's no paper trail. Candace, I was at a restaurant last night. I won't mention which one, but whenever I go out for it's always Chinese, right? So I won't mention the name of the restaurant, but I noticed that they never, when you pay by cash, they never enter the information in the cash register. When you pay by credit card, they do. Why is that?
They don't want to report it.
You were saying apparent authority arises based on what principle caused the third party, not the agent, to believe. And again, implied authority is what the principal believes. Apparent authority is what the third party believes. Agent has apparent authority when principal causes third party to reasonably believe what agent has authority to act for the principal. Apparent authority, pattern of conduct, apparent authority usually comes in existence over time. So Kobe, it's a question based on the relationship of the parties. That is, these are the past dealings that I'm dealing with you through my agent Candace, and based on our prior dealings, you assume that she has authority to do A, B, and C. See, business scenario on page 655. And Taylor, tell me what the facts are.
Janelle's a purchasing agent for a coal supply company, and they gave her the authority to purchase coal. So she goes and purchases some, but her car breaks down, and so she goes to the grocery store for help, and she meets a man who's selling land. And she thinks it has valuable coal deposits on it, and so she signs a contract saying the coal supply company will buy it, and then they're mad, and then they find out that the land is worth more than they bought it for.
When I listen to the tape, it's going to sound like that was Jody talking. So I should not ask Taylor a question either. So then, Linda, help me with this. Let me diagram what's going on. So we've got an agent who has authority to do what?
Purchase coal needed by its customers.
Buy coal for manufacturing process. And so she's on a trip to the mountains of West Virginia, and her car breaks down, and she goes in this little country store, and the owner is saying, you know, I'm desperate for money, would you like to buy some land? Now it seems like to me, Colby, that's exceeding her authority. Her authority is to buy coal. But then, Linda, why is she interested in this land?
It seems like it's a good deal.
And there might be what on the land, under the land?
Coal.
So arguably there are two ways to acquire coal. One is to buy it. Secondly is to buy the land in which it is located. But Kobe, her authority was only to buy coal. Now I think, when I first read this one, I'm thinking, what does it matter? What does it matter that her car breaks down? I'm trying to, what's the connection between the car breaking down? Do you see a connection there? What's the connection? Well, first of all, that's the explanation of why she is talking to the guy who wants to sell the land. But it also goes to Kobe what he thinks she has authority to do. He may think she has more authority than she actually does. And she actually, Linda, winds up buying it for $1,500 per acre. And then she goes to tell the principal, and AJ, the principal, says, what the hell? Your authority is to buy coal. We don't want you to go buy land. And then, AJ, they find out that it's actually worth $15,000 per acre. Then Brandon, the principal, changes their mind. Okay, so Linda, what's the principle of law here? Principle of law is that, number one, the principal will not be bound because she did not have the authority to do this. It's debatable about whether it's reasonable that the principal thought she did or not. But in a sense, AJ, it doesn't matter because the principal will not be bound unless the principal ratifies. Are they going to ratify this? Yes. Now, Linda, you remember, though, from our earlier discussion of basic contract law, here's another thing that nags at me about this. It seems like that the seller could rescind his contract based on mutual mistake. Except there's probably no mistake. Why? Because the other fact that we know from the case, Linda, is that the seller is what in the real estate trade is called a motivated seller, which means what, Alex? You're nodding your head like you know what that is.
Well, he said he was desperate.
He was desperate for money, and therefore that negates the argument about mutual mistake. Clearly, the agent made a mistake, but I don't think you could say that the seller did, because he's willing to take $1,500 per acre because she's willing to pay money today. Questions, comments? Turn the lights back. So Angela, you can go back to sleep. Parent authority. Parent authority in estoppel, if third party changes legal position by relying on the principal's representation, the principal is stopped, prevented from denying agent had authority to contract. So therefore, Cody, you're the third party dealing with me through my agent Candace, and even if she did not have a parent authority, if you put yourself in a bad position because you relied on her assertion of authority, then I'm stopped from backing out of the contract. And Kelsey, I think that's simple equity. Emergency powers arises when agent should protect the principal. Agent cannot communicate with principal. Candace, so you have authority to act on my behalf. I give you authority to sell my house, and then I go away for, I don't know, where should I go? Where should I go? Tibet. To go to a Buddhist monastery and find Wednesday. And so I'm going to be gone for 18 months. In the meanwhile, the state of Missouri wants to build a highway through my property and wants to condemn my property. And do you now have the, and I'm in Tibet and you can't contact me. Do you have authority to negotiate with the state for a better deal? And the answer is yes, because you have an obligation to protect me and you cannot communicate with me, therefore we give you emergency power. But it seems like to me, Kelsey, that's a rallying string case. Ratification occurs when the principal accepts the responsibility for an agent's unauthorized acts being expressed and implied. Requirements: agent must act on behalf of the principal. Agency must affirm the entire deal. What does that mean, Kobe?
All or nothing.
All or nothing. So you can't say I want to ratify clause A, but I don't want to ratify clause B. It's an all or nothing proposition, and I think, Alex, that seems fair. Principal must affirm before the third party withdraws from the transaction. So, Alex, let me make sure I understand that. So Candace is my agent, and she enters into a contract which exceeds her authority, and then she says, oh my God, I've exceeded my authority, and then she notifies the third party. Then I come along and I want to ratify. I can't do it because she's already passed out. Already passed out. Already backed out of the deal. Principal and third party must have legal capacity to contract when the agent made the deal. Principals must know all the material facts involved in the transaction. That makes sense. Principals are classified as either disclosed, identity is known to the third party, or partially disclosed. The third party knows he's dealing with an agent, but doesn't know the principal's identity. So here, Kobe, you know that Candace is an agent for somebody, but you don't know who it is. So therefore, what is disclosed is the fact that there's an agency. What is not disclosed is who the principal is. And then there's a undisclosed, when the third party does not know he's dealing with an agent, or the agent is the principal, and therefore the principal's identity is totally unknown. Cindy, why would you want to do that?
if it might affect the actions of the third party if they know who they're dealing with.
Yeah, so let's go back to the 1960s, when Disney was buying up land in Florida. And Disney is going to do what? Build Disney World, or which one? Disney World? Which one is in Florida? Disney World? Because and Michael, you appointed as the agent by Disney to go in and do this. If the landowners knew that they were dealing with Disney, that the price would go sky high, and therefore you don't want the third parties to know. Cindy, is that ethical? I don't know. It's certainly legal though. And I think, Michael, it's understandable why you'd want to do that. The other alternative, AJ, would have to have a partially disclosed. Again, in partially disclosed, I know that I'm dealing with an agent, but I don't know who the principal is. But Michael, don't you think in the 1960s when somebody's buying up land that there's all kinds of rumors going around? And do you suspect that the latter purchases would be more expensive than the earlier purchases? I mean, first of all, Kayla, that's the way supply and demand works. Also, the rumors would be speculating that there's some big money involved here. We want to do big things and turn a swamp into a, whatever it is. Authorized acts. Disclosed or partially disclosed principal, liable to third party if the agent acts within the scope of authority. Agent has no liability to third party for disclosed principal's non-performance. And Candace, that makes sense. So I appoint you as my agent to sell my land to Kobe. Kobe gives me the money, and then I go transfer the land. Can he come after you? The answer is no, because he knew he was dealing with me. Although you may be liable if the principal is partially disclosed, and you will be liable the agent will be liable if it's undisclosed principal, because Kobe, you thought you were dealing with Candace. Undisclosed principal, no liability unless the principal is expressly excluded, or the contract is a negotiable instrument, special rules for negotiable instruments, or the agent's performance is personal. For example, Candace and I have an accounting firm, and we provide accounting services for Kobe, and actually he's dealing with me, but he doesn't know it, but you do the work, so therefore your performance is personal, he can hold you liable. Kelsey, what does the first bullet mean? Principal expressly excluded. Let's suppose Kobe thinks that there's a principal behind the deal. Kelsey, could Kobe include words within the contract that says the principal, if there is a principal, the principal will be liable? And the agent has to show that contract language to me, and presumably, if she does her duty, I know about that, therefore I've agreed to that term. That makes sense? Otherwise, I have no liability. Undisclosed principal, no liability unless third party would have contracted the principal if she knew the principal's identity. Let's talk about the Williams versus Pike case. Kayla and Tellini, I'm going to turn the lights on so I can diagram this. So, Angela, zoom in on the blackboard. So, Kayla, let me see what's going on here. And Kayla, I get lost in the names, so let's use symbols. A will stand for agent. P will stand for principal, and B will stand for buyer. Okay, so agent sells a car to the buyer. And it's undisclosed principal, which Cellini means what?
The buyer doesn't know
The buyer does not know about the undisclosed principal. And then, Kaylee, due to mechanical problems, the car catches fire. Car is burned. So Kayla, this seems like a simple tort case. Seems like a simple case of negligence. And then the buyer sues. Well, but then the buyer says he's having bad luck. Then the buyer takes the car home, and the car is stolen. So the buyer sues the agent and the principal. And Talini, the court renders a judgment for the buyer. And they awarded a judgment of $2,000, one at the full value of the car. And what the court says is that it is negligence on the part of the buyer because she let the car be stolen. So that's why the award was only at $2,000. And that's an interesting case, Talini, but that's a matter of negligence law. So how's it relevant to the agency principle? So I know, well, let me ask you two questions. And remember, Kayla, that the liability arises under tort law. Liability does not arise under contract law. So, Kayla, why is the principal liable? And then, Talini, why is the agent liable? And does that mean that Alex, the plaintiff, the buyer, is going to double collect? No, but she can go after either one to get that $2,000. So my question is, Kayla, why is the principal liable? Under contract law, he would not be, because he's undisclosed. But who's the car caught on fire because of his negligence? Therefore, the principal is liable because of his own negligence. Okay, Talini, that seems fair. But the agent is not responsible for the mechanical failure of the car, is she? Ah, and the buyer thought that she was dealing with Ed. So because of so now if Candace, this had been a disclosed principal, then A would not be liable. Because A is not responsible for the negligence, and the buyer knew that she was dealing with P. So let me do this again. Kayla, P is liable because it's his negligence. Talini, A is liable because it's undisclosed principal. Everybody agree? And because of the point to take away here is well, what would you say? Candace, when we get into real cases, we get into really, people get greedy and everything. Candace, who are you sympathetic to in this situation?
The buyer. And, yeah.
I'm sympathetic to the thief. I mean, because, Katie, the thief worked hard, and what does she have to show for her thievery?
Car that was on fire.
But then maybe, Angela, I should not be so sympathetic to the thief, because the thief is incompetent. Angela agrees. Unauthorized acts are outside the agent's express, implied or apparent authority. If the agent has no authority, principal is not liable, but the agent is personally liable. And Megan, that makes sense. If Candace exceeds her authority, then Candace should be liable for, Candace, why are you liable if you exceed your authority? Because you shouldn't do that. Agent is liable to third parties for her own tort.